All right, welcome back to the LawNewz Network. We are on a sidebar in the Adam Matos trial, and it looks like there's some issues with this line of questioning. I'm joined with our guest in studio, Brian Wagner. He's a criminal defense attorney and former prosecutor. Brian, what do you think the issue is here?
So Caroline, at this point, they're asking about an email that Ms. Thomas sent. And the issue is whether or not on August 28th, the victims, or Maggie Brown, stopped communicating with Ms. Thomas. What the people are trying to establish is a timeline. The last contact she had with anyone was on August 28th. The issue, although I don't know, at the base of the defense objection will probably be that Ms. Brown never responded to the email, therefore this timeline doesn't really establish anything.
Right. And I think I heard one of the objections was unresponsive. You heard the prosecutor ask this witness when the last time was that she communicated, I believe with any of the victims, but specifically with Mag, who she's calling with her stepdaughter. And she gave a pretty roundabout answer. I was actually surprised that the defense didn't make an objection sooner. And obviously the objection was non-responsive, but I do believe that objection was overruled by the judge because this witness was talking about her public posts on Facebook. She discussed how on August 26th, one of the victims, Margaret, posted on her Facebook page that she was in St. Pete on the beach with her husband of however many years. The day after that, apparently she made her, as the witness described it, her last public posting of a campfire. She posted that on Facebook apparently because she was on a camping trip, and she sort of made a joke about that. She was posting a photograph of a campfire even though it was 90 degrees out. And then right before we went to sidebar here, we heard from this witness, again, it's Linda Thomas, who is Margaret Brown's stepmother. We heard from her that either on the Thursday or a Friday, she had received an email from Margaret Brown, potentially. Looks like they've cleared up the issue, and we will be going back live into that courtroom. We're just waiting to make sure that we have audio. We'll go back there. Well, it looks like they're actually still talking about something. Prosecution, Brian, really going through these witnesses pretty quickly. I mean, it's quite efficient.
Yes, what the people are trying to do at this point is just lay a timeline. And
okay. Let's go live. Can we go to a shot?
Thank you, Ms. Thomas. Do you need to use the restroom or anything? You're okay? Okay.
Yes, thank you.
If anyone else needs to use the restroom, I'm going to take a 5-minute break. If not, Ms. Thomas, I'm just going to have you stand there. That way you don't talk to anybody, okay?
Welcome back to the LawNewz Network. I'm your host for this afternoon, Caroline Polisi, and court is on a 5-minute recess in the case of Adam Matos. He is on trial for a quadruple murder, quadruple homicide, and we're very fortunate enough to be joined in studio today with Brian Wagner. Brian, thank you for being here.
thank you for having me, Caroline.
You're a former prosecutor, now a criminal defense attorney, so you can speak to both sides. Just initial thoughts about what you think this prosecution's case is making out to be.
So the people opened today and they gave an outline of what they expect the evidence to prove. It sounds like a very strong case, but until the defense attorneys get a chance to cross-examine and pick apart this case on the margins, and that's really what they're trying to do. They're not going for huge over-the-top winning arguments. What they're trying to do is erode the credibility one step at a time, so when they present their case, if they present a case, they know what they're actually going for. And then on summation, they could sum up and tell the jury that the people failed to meet their burden. That's all that they have to do. They don't have to do anything at all. They just need to say that the people didn't meet their burden. That's really what they're trying to do in this case.
Right. I'm actually surprised, we were talking about how sort of unusual it was for the defense to punt their opening until after the prosecution made their case. But I'm surprised actually that more defense attorneys don't do it. I think just maybe it's a sort of a human psychological issue in terms of like you always want to, if you can speak now, you want to speak now. But I think it might be a really smart tactical move on the part of the defense to see what the prosecution has prior to making their theory of the case.
It requires, one, a lot of confidence in your own attorney abilities, and two, a lot of confidence the client has in his attorneys.
Right.
And in this case, I'm sure the defense attorneys didn't do that decision without consulting with the client. But I think what they probably explained to their client was, we don't want to overpromise in this case and then not be able to deliver. Let's find out what the prosecution's weaknesses are, and then we can hone in and really attack those parts. And you see it in the defense attorney's cross-examination of these witnesses already. With Ms. Thomas, they haven't cross-examined her yet, but the last witness, the 911 technician.
Right, Tammy Dutton.
Absolutely, they didn't really touch her that much. It's the second officer that testified that on August 28th, he responded to the scene. They got 2 or 3 points. That's it. And then they sat down. Their cross-examination, maybe 5-6 minutes at most, because what they're trying to do is get just little tidbits of information that the defense can then use if they put a case on, or better yet, on their own summations.
Right. You can run into a lot of problems just as a defense attorney if you really try to attack those prosecution witnesses that are, that did nothing wrong, they're merely witnesses or what have you. It's a dangerous path to go down to be overly aggressive on cross, I think, and I think you made a great point that they are not falling into that trap here. The defense is being, I think, quite cordial, polite to these witnesses, just merely trying to get to the heart of the facts of the case. Let's talk about Deputy Frederick Heidrichen. He was the patrol deputy on service, and he, I noticed you said something off camera, which was that in this initial early morning call, it was kind of a long time for him to have been at the victim's residence. What do you think was going on?
So it's interesting. He gets a call around 6:11 in the morning, and he responds to the scene. He spends roughly an hour and a half at that location. He also did something that's called canvassing. Very simply, he gets a description of the alleged perpetrator, and then he drives around trying to find that perpetrator. He was asked by the prosecutor, did you use canines, using a dog to use that person's scent to try to locate him? The deputy said he did not. Those are the small type of wins that this defense attorney is really going to take. And you'll see, or you saw in his cross-examination, again, what he asked was, did the victim in this case have injuries to her neck when you spoke to her? He said no. That's important because the 911 call that the victim makes says he held a knife to my throat. And so what he's going to do is put together these small little inconsistencies, these small little throwaways to make a much larger point that the people's case just simply doesn't add up.
Right. What about that point we saw the defense ask about the 911 call? I believe it was the first witness on the stand this morning, really harping on the fact that the initial 911 call was didn't go through, or it was a hang up on the part of the caller. What's going on there?
So I think that's one of those things where you don't really know what happened.
Right.
And since there's ambiguity typically helps the defense. Because what the defense then gets to say is, look, the people have the burden to prove this case beyond a reasonable doubt. You don't know A, B, C, D. And therefore that's reasonable doubt. Whether or not a jury buys that argument is ultimately up to the jury. But what you want to do as a defense attorney is poke holes where you can and create ambiguity, because ambiguity, tie goes to the runner, ambiguity goes to the defense attorney. typically.
Interesting. We also saw up on the Elmo, we saw the prosecutors put on the photographs of the injuries sustained by one of the victims in this case. And I'm wondering, was that the subject of those motions in limine that we were discussing earlier today?
So we had motions in limine before trial, after the jury was selected, before opening statements. Those motions in limine were really about on September 3rd when the bodies were discovered.
Okay.
And there's a motion in limine by the defense to preclude essentially crime scene photos of the deceased and their body parts after they are located. The argument is that these are so graphic that the jury will be overcome by sympathy and won't be able to determine the facts. It's a very standard motion that defense attorneys will file on homicide, and you heard from the judge there's nothing unique about these photos, and that's why she allowed them in.
Right.
But it's absolutely a defense motion that you should make, and they did.
Right, because I was going to say the pictures that we saw just now were really not that, were not as bad. Actually, having heard the 911 call, I expected there to be sort of deeper injuries or more substantial injuries on the part of the victim. But it didn't seem to be as bad as I would have expected.
And I would expect these photos, the defense to use to their advantage, for the very reason that we just talked about, with the no injuries to her neck.
Right.
All she had was a small abrasion to her thumb. And the argument is that if you are putting a knife to someone's neck, you'd expect injuries to your neck and not this small abrasion to your thumb. So maybe the victim was prone to exaggerating. That's the argument that the defense may make, or they might not, depending on how the case goes, but they're not committing one way or the other at this point.
Right. We were also commenting that there was a lot being made by these witnesses about sort of the setup of the home and the nature of what was inside that home. And you had a great sort of theory as to why the prosecution was laying this foundation, which is?
Just basically, at this point, the prosecution is taking this chronologically. They want the jurors to be able to put themselves into that location as much as they can. So you see them doing something called a double direct. They go through the entire questions without any assistance of exhibits. And then once they've done that and the jury understands the basic facts, they now use these exhibits, these photos, so that the jury can more fully understand. It's a double direct because you're doing it twice.
I've never heard that before. Interesting. Also, but about I think you said, I was asking, well, why are they making such a big deal about this television and sort of the sound system? But you made the case, remember, what we know about this case is that the defendant sold a lot of this equipment.
And that goes to the defendant's consciousness of guilt, is
Right.
what the prosecution is going to argue. That the defendant's actions, although they're innocent all by themselves, coupled together in the totality of the circumstances, it shows that he has a consciousness of guilt, that he is doing things that suggest to you, the jury, the only logical conclusion is that he was the one that committed the murders. For example, the entertainment center that you're talking about, the entertainment center was sold sometime between August 28th and September 3rd when the bodies were found inside the home by this defendant. And so that is a good indicator that he was inside the house and that he was the one that allegedly committed these murders.
Right. And the consciousness of guilt factor, if that sounds familiar to some of our viewers, there was a big motion over the consciousness of guilt issue in the Lewis Toledo trial. I don't know if you remember this, but during one of the replays of a police investigation video, Lewis Toledo, the defendant in that case, attempted suicide. And of course, the defense made a motion to keep it out, but the prosecutors argued to let it in as consciousness of guilt. And the judge bought that. And I think contrary to many, certainly to myself as a defense attorney, I was sort of shocked because I did not think that indicated consciousness of guilt. But I think here, where you're talking about sort of, selling the evidence or exactly what you're saying, I think that's more indicative of sort of a consciousness of guilt.
And that's a great point. With consciousness of guilt, the fear of having a consciousness of guilt argument to the jury is that they have to accept an innocent explanation. Whereas if there's no innocent explanation of the totality of the circumstances, they should infer guilt.
Got it. Okay, I'm hearing that we're ready to go back live to the courtroom. Brian, thank you so much for being with us today.
Thank you very much
Please
for
come
having me.
back. You were
Absolutely.
a great guest. We'd love to have you back. And we're going to take you live to the courtroom.